Welcome back, viewers. You're watching the Savera and I'm Shefali. In a major clarification that comes as a relief for thousands of skilled foreign professionals, the US Department of Homeland Security has issued fresh guidance regarding the newly announced $100,000 H-1B visa application fee, specifying key exemptions and eligibility criteria. The clarification removes uncertainty and anxiety among existing H-1B visa holders, students and employers who had feared widespread disruption. Now, according to the update directive, the hefty $100,000 fee will be only applied to new H-1B visa petitions filed from outside the United States, where the applicant does not already hold a valid H-1B visa. This means that current visa holders, as well as those seeking extensions, amendments or change of the status within the country, are not subjected to the new fee. Officials also confirmed that individuals transitioning to H-1B status from other visa category, such as F1 student visas or optional practical training (OPT), will have not to pay $100,000 charge. Furthermore, the clarification ensures that existing H-1B visa holders can continue traveling freely without restrictions or re-entry. The proclamation applies solely to first-time H-1B applicants outside the US, a DHS spokesperson stated, emphasizing that the change is not retroactive. The department has also launched an online portal for new applicants to process the required payment. The announcement follows widespread confusion and backlash after President Donald Trump's September 19 proclamation, which introduced a steep visa fee as a part of Hire American policy aimed at prioritizing domestic workers. Critics argue that the order was valuably vogue and appeared to affect existing visa holders as well, prompting panic among H-1B professionals, especially those of Indian origin. The US Chamber of Commerce, the nation's largest, busiest advocacy group, filed a lawsuit against the Trump administration, calling the fee unlawful and economically damaging. The lawsuit, filed in a Washington, D.C. district court, argued that the policy would inflict significant harm on American businesses by raising labor costs and deteriorating employers from hiring skilled foreign professionals. The rule would force companies to either pay exorbitant fee or forego hiring the highly skilled workers they need, workers who are not readily available domestically, the chamber said in its filing. Now, the legal challenge follows another lawsuit filed earlier in October by a coalition of labor unions, educators, and religious organizations who accuse the administration of violating immigration and labor laws through arbitrary policy decisions. The White House, in an earlier clarification to media on September 20th, described the measure as a one-time fee applicable only to newly issued visas, not renewable or current holders. India continues to be the single largest source of H-1B professionals, with India-born workers accounting for over 70% of approved H-1B visa in 2024, largely due to the concentration of skilled technology and engineering talent. For now, the DHS clarifications has offered relief to tens of thousands of Indian IT professionals and US-based employers who rely heavily on the H-1B program to fill criteria holes in science, technology, and research sectors. However, immigration attorney cautioned that further rule changes could emerge as the policy continues to face judicial and political scrutiny. That's all for now in this update. Stay tuned to the Savera, download the app, and follow us on various social media platforms.